Hi, and welcome to another episode of NCBA's Coffee Break. I'm Nathan Willner, Vice President of Government Affairs, and your host for another episode with some really top legal minds. And I'm so excited to have with us today Adam Cleveland and Tasha Zeigler, both expert attorneys, but maybe on different sides of the aisle on some issues, but not on others. So let's find out a little bit more and dig in. I'm going to start by asking you to introduce yourself. We'll start with Adam. Give us a little bit of your background and why you're on our coffee break show today.
Sure. I'm Adam Cleveland. I'm a longtime maintenance guy turned lawyer who now happens to be the present chair of the creditors' rights section of the Georgia Bar, which is not the role I'm in today. It's just a credential, but that's the path I took was maintenance guy through law school, became lawyer, and this was the realm I landed in because I like fixing things and this gives me a chance to do that.
All right, well, let's find out who your partner in crime is, so to speak, on today's episode, who can help you fix things. Tasha, give us a little bit of background about your journey into the legal career.
Absolutely. I'm Tasha Zeigler. My entry into the law started as a Chick-fil-A worker through high school and college who decided, I want to make chicken for some consumers. I've been a consumer protection attorney for 20 years this year. I'm the chair of the consumer protection section for the State Bar of Georgia. And I believe that Adam and I work together really well in order to resolve issues for our respective clients.
Well, first of all, that's fantastic. But that's sort of not what I think about intuitively when I think about the law. I mean, I know uh, in the United States we have what's called an adversarial legal system, which means there's two sides that are adversaries. So, how is it that you can work within an adversarial system but not really necessarily be adversaries?
Well, Tasha, you want to go?
I was just going to say, I think it has to do with the expectation of what an adversary is versus like out in the wild versus what our lived experience is as attorneys. And our practice requires that we take opposing positions, make opposing arguments, and represent our clients zealously, but it does not require that we dislike each other, that we cast aspersions against each other or the other side's client, and that really we're trying to come to a resolution that benefits our individual client, but doesn't necessarily mean we have to beat the other side into the ground.
Yeah, I think that's a great way
That's
of phrasing it.
Yeah.
And I think, part of the issue is that these cases that are in this space, the kind of creditor-debtor space, are really about a problem. And the problem is that, generally funds left someone and were supposed to come back and didn't. And now it's perfectly possible for two parties on opposite sides of that problem to look at it and figure out a way to solve the problem without feeling like they are the problems themselves.
Absolutely. And I think that most folks that do this kind of work would come to the conclusion that two things. One is that every consumer wants to pay their bills. I mean, that's the last thing they want is not to pay the bill. And also, from the creditor's perspective, the last thing any creditor's attorney wants is to collect one dime that isn't owed. Literally, like if the consumer doesn't owe the money, we're not interested in collecting it. And I think those are things that many people maybe intuitively don't think about. Um, they also don't think about, like, many times consumers don't have lawyers, and I think there's a feeling like, oh, great, the other side doesn't have a lawyer, I have the advantage. But that might not be really how we look at it. Is it, Adam?
The This will reveal my inner nerdiness. I sometimes think of myself as Cassandra from the mythology, the prophet who is always right and never believed. That's the experience I've had for all these years. When you're talking to folks who, don't know the law and yes, for sure, by and large, folks, especially when you're working for first party, creditors, go, yeah, no, I own the money, this is fine. But you talk to a lot of folks who are like, I saw on the internet where I can send you this thing with my red thumbprint on it, and that'll get, or God only knows, and you just go, God, please, could you just maybe talk to a lawyer? I have said the words, could you maybe talk to a lawyer a lot. Because yeah, you don't, it's not always advantageous for someone, just like that old, bromide that the lawyer who represents himself as a fool for a client. I mean, that's all of us if we go in there without somebody who's objective and distant from the case and a professional to tell us. So it is definitely different. And I think from state to state, there are places where the two sides of the bar on this issue are more adversarial. There's a lot more kind of countersuit. I mean, a lot of places where your consumer bar representatives will bring an action against the plaintiff's attorney immediately, whereas here you would have to actually be doing, like, for 90% of the consumer bar here, you would have to actually be doing something very wrong and ignore repeated mentions of it before they're like, well, what am I going to do now? I got to see. But the suing first and asking questions later is not the MO down here.
Yeah, so
Yeah.
Tasha, folks that come on our coffee break many times are working on the creditor side of the coin. So I'm just really curious to know from your perspective, what has been your experience dealing with our lawyers, and hopefully it's been positive. What kind of things have struck you as out of the ordinary, where maybe intuitively you didn't think that was so either when you started?
So I would say working with the creditors bar, if it were terrible, if I hated it, then I would not still engage in that particular area of law. But the truth of the matter is, I like solving problems. I like a mystery. I like to go like Columbo and say, but there's one more thing. So when I'm interviewing a potential client, so a consumer comes and says, hey, I need help. Could you represent me? And I'm going through the documents with them. It may help the creditors bar to know we typically don't take every case that walks through the door. So we want to see some openness, some truthfulness from our prospective client. And sometimes there's just a severe lack of understanding of the documentation that was signed, the agreements that were made, and the curiosity for the consumer isn't really ignited until there's a problem, because there is that lack of education, right? There is that, and the law takes that into consideration, the unevening bargaining position. And consumers, I hate to say this, in Georgia, there is an inherent vulnerability and misunderstanding about how credit and debt work, how important it is to read the agreement, what the terms mean. I spend a ton of time educating consumers. I try to educate them before they get into trouble. But if they get into trouble and they come, the great thing is, in a lot of instances, I can actually pick up the phone and call someone on the other side and say, can we look at this? Is this one different than the last one we did 3 months ago? Like, what am I missing? Or I can say, I'm looking at the documents. I see a problem here. Is this something that we can talk about? And there is an opportunity, even before there's a formal mediation, or even at the courthouse steps of mediation, that we can resolve it over the phone and some emails. And I will say the creditors lawyers in Georgia are very, very good about coming up with creative solutions that will make their clients happy and keep my clients in a place where they're able to repay the debt.
Yeah, I mean first of all, that's great to hear that there is a literal relationship, and I think what it comes down to is trust, right? I mean, after a while, you know who to trust and who you don't, and what is, people forget is that it's not one and done. I'm going to see that same lawyer again. I'm going to see that same judge again, and the way I handle myself in court is going to be remembered, both for the positive and the negative, and so much of that really. It is everyone benefits, the clients benefit and the court benefits and the consumers benefit, because at the end of the day, really setting up a payment arrangement that the consumer can't afford, that doesn't help anyone, right? And creditors have enough pieces of paper that say Mr. Smith owes ABC company money. We don't need another piece of paper. Like, there's this misconception that people want default judgments. Absolutely not. We have enough pieces of paper that say you owe money. We really want to work something out where you can get into a payment arrangement that that works. So anyway, we're getting kind of sort of the end of our cup of coffee here. I'm going to kind of put you both on the spot and say, if you could fix one thing in the process or one area that we need to focus on, what would that be? And I'm going to start with Adam. So Tasha, you get the final word. So Adam, what would you fix if you could fix one thing, or where should we be putting our focus on?
That's a great question. And man, I wish we had some prep because I feel like Tasha and I could really make some headway at the state legislature with some ideas we could have. But I think two things. One, cooperatively, I wish there were, you know what, this solves both actually. I wish there was some different designation of suits when they were identifiably creditor debtor. Like we have drug courts for criminal stuff. We have, business court for financial matters, but the literal majority of civil suits in basically every state are creditor debtor suits. And they get put in their own dockets, but they are still mixed in and they're still treated the same way, that same adversarial system, the same pleadings, the same, motions practice. But I feel like if you're willing to, like, we should commit to having a different type of court, a different process that is more cooperative, more mediation centric, like just an audit, like a pipeline of how we get even the non-represented parties into these cases, get somebody, I mean, hell, if we had an advocate, ad litem for each one, there's ways that could be done that might make it better for debtors and creditors at the same time and not put them into this unreal world that doesn't really fit the situation.
Okay, yeah, absolutely. And I think that's so true. Tasha, not to put you on the spot, but
That was
how are we
fine.
gonna make things better?
I love that idea so much. So I want to give props there. I am, and I tell folks this all the time. I am a true believer in consumer protection. Like it's in my bones. And what I've seen is long time ago when I worked for the government, there's this push to more pieces of paper, have people sign more things. But the problem is that they don't understand what it is that they're signing. We can have all of these disclosures and disclaimers and signed by the X, but they don't understand what they're signing. And so it would be fantastic if I could change one part of the process. If there was mandatory education for consumers before they entered into a loan that could end them up in, or where they could end up in this adversarial process, where they may end up unrepresented. They do not understand how the magistrate court, superior court, or state court system works. They don't know that they have the right to appeal. If we could keep them from even getting into that pipeline so that they could make the educated decision about whether they want to enter into the transaction in the first place, I actually don't think it would decrease the number of transactions. I think it would
I agree.
probably stay the same, but you'd have a better chance of the loans actually being paid off. Maybe folks would decide, I don't really need to borrow that much, right? I should borrow less because I understand at the end, if I can't, that it doesn't just go away. Bankruptcy might not be an option. I really care about my credit. Just because I can afford it today doesn't mean I can guarantee I can afford it in the future, because a job might not be there, right? An unexpected illness. If we could teach consumers that, both the consumer and the creditors bar, if we could come together and teach them and level the playing field a little bit, I think we'd have fewer cases even going into the pipeline.
Yeah, I think that's 100% correct. And look, how often are you in court, any one of us, and you hear, or even on the phone, you hear a question of, am I going to go to jail? Or right? And that just shows you that that there's a disconnect in our educational processes where the average citizen just doesn't understand civil law, criminal law, just like very, very basic. I'm not talking about the level that an attorney goes through to understand our judicial process and our system and the constitutional system that our country has, but just to understand that no, if you get sued for a credit card or for a car loan, you're not going to jail. Don't be scared. Make a phone call. But again, even all these court notices, if you look at them, and more information is great, but it's written in such a way that if I didn't know anything, I'd be scared out of my wits. Big letters. Don't do this. Stop. Don't cross go. Don't look at this side of the paper. Don't turn it, horizontal. I don't know, but it scares the crap out of people. And if we don't write those notices better, people don't know what to do.
They don't, and people hide, and it makes, like you said, pick up the phone, call. People hide. They don't open their mail. They don't answer the phone. They don't know that a notice came. If they read it, they're too scared to go, and it just gets worse and worse. It'd be great to keep folks from having to go on the pipeline. Then Adam and I can do another part of what it is that we do, right? We're not.
I think,
yep.
I think what you're hearing is us agreeing in this phone call that Tasha and I are going to start doing a community outreach, just going across.
Just going to get
counties.
We're just
I
going to
know,
start get big microphones and just go across.
I mean, we really could reach out to institutions. I mean, I don't care if it's churches or synagogues or whatever you've got locally. But
Yeah.
this is a great adult and child education that people don't have and should. And who better to say it than us and go, look, here's what you should know, to have agency, to feel like this is, because people get in hopeless situations and bury their heads or run away because it's a natural instinct when things feel like they're just all caving in on you. But
Yes.
you can take those steps if you know what you're doing and don't feel like it's hopeless.
Absolutely fantastic. I think we've got the start of another program. I guess Adam has a lot of extra time on his hands, so there we have. But no, but you're 100% right. And if you educate people, especially in a congregational setting, whether it be a church or a social group or something like that, that person can then be a trainer for other people when they have problems in that same community. And they can talk them off the ledge, so to speak, and say, look, here's what I did, here's what you can do, and just give them some basic resources. So I think you're definitely onto something. But anyway, we have come to the end of our time, and I hate to say it, I'm going to invite you back. So you're not off the hook yet, because there's so much more I have to ask you about. And I really think we've kind of lit the fire to kind of make a difference. So anyway, thank you so much. Thank you to our listeners, and we're going to have you back again soon. So thank you, everyone.
Thank you.
Thank you.